most respected guests, senior members, and all gathered here. A very good morning to one and all. I, Dr. Subbalakshmi, Assistant Professor, School of Law, Pondicherry University, take this privilege and pleasure to welcome you all on behalf of School of Law, Pondicherry University, to this special lecture on ancient Indian law.
Sir, we are immensely honored by your presence with us, and thank you for being generous with your time, and we are very eager to listen to what you have for us this morning. You know, it is in looking to the past we learn lessons for the future. So today, Sir is going to take us on an expedition digging into the past. Who knows, that's where the answers to the future lies, not just for our country, for the world as well. So I'm so glad we have Mr. Justice with us this morning. And I'm very happy to welcome our Honorable Vice Chancellor, Professor Gurmeet Singh. Sir has been an immense source of strength to the School of Law. It was during his tenure we have several landmark developments in the School of Law. Sir, we welcome you to this special lecture. We are also very honored to have our Director of Studies, Professor Tharani, with us. Sir is such an astute, administrator, and he gives us a lot of positive vibes whenever we go to him with all our proposals. I also welcome colleagues, the directors and the faculty members from other schools and departments. And I also welcome the students. School of Law, well, it's been just 2 weeks since you joined. This is School of Law, and our job is to create opportunities for you to learn and then bring in some fantastic resource persons and see, I hope you would see yourself in their shoes one day in the time to come, and they model great, lifestyle, great principles of integrity and practice as professionals before you. So I'm so happy for you. Welcome, students. So on this note, I would again welcome all of you to the first special lecture organized by School of Law for this academic session. Thank you very much.
Thank you, sir. As a token of our respect and happiness, we would like to honor our respected guest for today. And I humbly request our Vice Chancellor, Professor Gurmeet Singh, to kindly honor the most respected chief guest, Honorable Mr. Justice Vivek Bharti Sharma, Judge High Court of Uttarakhand. So we have also placed our souvenir for School of Law alumni, which was recently hosted 2 months back. We would like to hand over the same to our chief guest today. May I now request our Dean, School of Law, and Professor Tharani Karasu, our Director of Studies, to kindly honor our Vice Chancellor. I now humbly request our Honorable Vice Chancellor, Professor Gurmeet Singh, to kindly deliver the presidential address. Over to you, sir.
Well, friends, very good morning to all of you. When we announce this talk, you must be having a picture in your mind that Justice Vivek Bharti Sharma would be giving a talk, and he would be one of those with gray hair and some wrinkles on the face, and would be wearing a typical white shirt, which people in law are very used to. But you would be very pleased to find a young man looks around 30 years to be with you as a High Court judge, which is a very rare thing. So I am very delighted to have Justice Bharti here with us for a very important talk, which is on ancient Indian law. And whenever we talk about ancient Indian law, the feeling that goes around in the minds of young law graduates is, what do we talk about ancient Indian law? What is there in Indian law? Law is what we have learnt, and that has filtered down to us from various other quarters, where in fact we are the ones who have told them what is law. If you go back to the ancient history, I don't know how many of you have studied about governance. It starts from Cholas. What a high quality governance we used to have during those times. And then it filtered down, and the best governance that we had were all from Indian regimes, finally culminated with what we see in Maharaja Ranjit Singh's governance, which was one of its highest class. So Indian law, particularly ancient Indian law, is one where we have to learn a lot from this. And that, if somebody carries out a comparison or a research, I think it will be one of the best areas to work in, and a lot of good things can be brought out about this. So I'm delighted that Justice Bharti has chosen this topic, which is close to at least my heart, but many law graduates would find it very interesting eventually. Coming back to law, I don't know, I'm a science person, and somebody will introduce Justice Bharti. When I was reading about his profile, he's a science graduate. And science graduates are one, it comes to them as a matter of habit that anything that they do it in a very meticulous manner. So he is from science background, and the moment I read his profile, you know, like a movie, many science profiles crisscrossed my mind that, well, they're all into law profession. I will not name, because otherwise you will think that I'm popularizing some advocates, which is normally not done. So there are many in Supreme Court and High Court who did their science graduation, then moved into law and became exceptionally wonderful advocates. They are respected, not only respected, in fact they are worshipped. I remember one of our classmates who did science, then became a Solicitor General and all through those. Now he is a walking computer in law. You tell him which section, which subsection, he will not have to look at anything. He'll immediately tell you at this page on this line will have this. I mean, it comes to him. I think that results from science. And when I read Justice Bharti is also a person in that line. From science, he moved to law and then has held a lot of important positions, including the one which is advisor to the governor. And you know, we say governor means governance. And governance can be good if there is a proper advice to the governor. And I'm glad that position he has held, from where he moved on as a High Court judge. So we are delighted to have him, very happy to have him, honored to have him in fact. And when he said if he's visiting our place, I requested him if we could interact and give a talk on a topic which is of his liking. And he says he'll be talking about ancient Indian law. I'm sure it'll be a very great eye-opener. Now coming back to law, it's a great subject, let me tell you. A subject which changes, which evolves, will always remain a great subject. And law is one which evolves itself every day. Every second day, you find there will be a different connotation to this. That's why we have one law, sometimes one section, but that is interpreted in so many ways that there's a full research carried out in that. That is where the greatness of law lies. I remember having heard Professor Upendra Bakshi we were talking about way back in 1991, where he said that there are laws of all kinds. Criminal laws are there, civil laws are there, marriage laws are there, but a kind of law which is yet to be evolved, and that was the first of its kind, if you look at the history. A law that is yet to be evolved is environmental laws. And from his talk, the whole world started working on that. And then what we now see is before us. So I'm saying law is a very evolving subject. It's a subject which requires a lot of research. And the moment you have a research in any subject, that would ultimately mean that this is going to be one of the best subjects to work on, to study. So this is that. And when we look at the other side of the story, They say subject is very interesting and good if it has a sense of comic in this. As long as it's not there, then it's a very drab subject. And let me tell you, law is one subject which has a lot of humor in it. If you have been reading Reader's Digest, you're an ardent reader of that. Probably during my time there used to be two columns: humor in uniform, humor in law. So it made wonderful readings. And one of the things I remember, which I read, what do you call when a father of church reads law? What does he become ultimately? They say it's father-in-law. So, these are the things which came in. And I also read Law of Justice recently. It just came in papers, I think 4 or 5 days back. What is law? He says law for a poor is he is guilty unless proved innocent. For poor. For a rich, he is innocent unless proved guilty. So it's a way you look at it, way you interpret. So this is a great subject, let me tell you. And you are all budding young persons who are going to be entering into this. So look at Justice Bharti's face. You will find if a person starts enjoying this subject, you are like Justice Bharti. I mean, wonderful personality, cheerful personality, no tension, right? And this is what you should be ultimately when you grow into subject. And one will grow into subject when you start liking, you start enjoying. This is what Justice Bharti has done. He's brought law to some of the remotest corners in the state he comes from, Uttarakhand. And it's a budding state now, doing very well. And law is respected in that state to the highest level. That's what is required. And you are one of those who will be ultimately the custodians of law. And we need that for our country. We need a kind of law which will bring our society to one of a real egalitarian level. And that could be done when we have people like Justice Bharti with us. We are in the safe hands. And I extend a very warm welcome to you, sir, for sparing your time here for this talk. He was here and he was kind enough. He said, yes, I would be very happy to deliver a talk. And as I said, our law department is a very young department. It's a budding, growing department. And a person like you, when you address here, I'm sure they are going to be in for getting a right direction for the right growth in this subject. And it will be a great addition to our own department also. We are all very keenly looking forward to your talk on ancient Indian law. And for these budding minds, I will say, please Google and see how many ancient governance systems that we had during Harshvardhan times. Many, there are 17, 18s which I counted, where we had the governance of highest kind. So therefore, please start respecting our own ancient system, where we had best of the governance, and best of the governance was there because people had a respect for law. This is what is required to be brought back into our society, and that would be possible when we have people like Justice Bharti amidst us, and I'm sure he is going to carry the flag high always in the years to come. Thank you so very much, sir. We are grateful, and we very keenly look forward to your talk. All yours.
Thank you so much, sir, for those words of enlightenment and encouragement to our current batch of LLM students. And yes, sir, we take it as a compliment that we see the sciences, people from sciences shift towards law, and let us feel proud and happy about that. And definitely, yes, law always has its hand over all the other domains. Law cannot be separated, and yes, as you know, law can never operate in vacuum. And now that there is a lot of influences of law in all the domains which we are seeing in the current setup. So thank you so much, sir, for your words. May I now request our Directors, Studies, Professor Tarni Karasu, to kindly share a few words to felicitate our guest for the day.
Good morning, everyone. Respected Honorable Mr. Justice Vivek Bharti Sharma, Judge High Court of Uttarakhand, and our Honorable Vice Chancellor, Professor Gurmeet Singh, and our Dean and our HOD of School of Law, and all the students. Good morning, everyone. So it is indeed very happy to be part of this. So as our Vice Chancellor mentioned, we have started the department department very early in 2013, but recently we have recruited it, and these are the wonderful chances. We have got the faculty members, and our dean is also arranging many invited talks. So kindly take this very seriously for your course. And while discussing these recent developments in law, especially the environment law, our Vice Chancellor mentioned, even the cyber laws also is now getting very important, and we are looking for good patent lawyers and even cyber lawyers. For our university, we are looking for patent lawyers also. So this is very important field. Please take it seriously. And whoever is coming for our resource person, please keep in touch with them. That will be, because law, as you know, you have the established one, but still how you interpret, that depends upon how you follow these different judgments, how you follow the contact with different network. All these are very important. So I thank our School of Law for organizing this seminar. I thank especially our Honorable Mr. Justice Vivek Bharti for agreeing for this giving this talk. I don't want to take much time. I welcome him for giving this talk. Thank you very much.
Thank you, sir. Thank you for your presence and supporting us throughout for all the events which are happening in School of Law. Thank you once again. Now for the attention of all the students present here, today we have with us the person who secured first batch of Higher Judicial Service 2005 in the state of Uttarakhand. I repeat, he secured first in the first batch of Higher Judicial Service 2005. Honorable Justice did his schooling from Ramjas School, Delhi. As sir has already pointed out, yes, he's a person from sciences. He did his BSc from University of Delhi and then LLB at the Faculty of Law, University of Delhi. Sir joined the legal profession in the year 1987 and practiced mainly in matrimonial, civil as well as criminal sides in the district courts as well as in the High Court. In 1990, sir was appointed as Government Counsel, Delhi Administration. In 1994, he was appointed as Additional Public Counsel of Government, Delhi. In the year 1999, he was appointed as Advocate of Indian Railways in the High Court of Delhi. In 2000, sir was appointed as Additional Standing Counsel for the Union of India. I repeat, for the Union of India. Upon joining the Higher Judicial Service, he served as Additional District and Sessions Judge at Haridwar, Roorkee, Haldwani and Nainital. And in 2011, he was promoted and appointed as Principal District Judge in Pithogarh and Pauri in 2013. Sir has also served on deputation as legal advisor, which was already mentioned by our beloved Vice Chancellor. He was deputed as legal advisor to His Excellency, the Governor of Uttarakhand, and later joined as Chairman, Commercial Tax Tribunal in Dehradun. In 2017, sir was appointed as Director of Uttarakhand Judicial and Legal Academy. In 2022, sir was appointed as Registrar General of High Court of Uttarakhand Nainital, and sir was elevated as Judge High Court of Uttarakhand from April 2023. It is definitely our pleasure, sir, having you here with us. And may I now request very humbly our Honorable Mr. Justice Vivek Bharti Sharma, Judge High Court of Uttarakhand, to kindly deliver the special address and to address our young students here. Over to you, sir.
Professor Gurmeet Singh ji has invited me here in your university to deliver a talk on the subject of my choice. And when he asked me that on what subject I would like to deliver my talk, so I was little perplexed because for many, many years, I have been interacting with either the trained lawyers, advocates practicing in courts, various courts, or the judges, or the administrative officers like IAS officers, IPS officers, because as Mr. Subbalakshmi has told that I was the director of the Uttarakhand Judicial and Legal Academy, where the training to the administrative officer, IAS, IPS officers is also being imparted. So this is the first time that I'm among the young people like you who either have just got the admission and not even got the initiation as such, or 1 or 2 years into this field of study, and certainly not in the profession as such. So I thought that there should be some subject which just can give you some idea exactly if law, in the realms of the law, is there any contribution of our country as such or not? So I thought that ancient Indian law should be the right subject because it will have some color of the history, it will have some color of the social sciences, it will have some color of the law, and the great thinking of the people, our forefathers. So it will be something little interest to you to just tolerate me for some time, because I just travel into hard subjects of law, so that will be something bringing to you sleep in the forenoon session itself. But one thing just I would like to take the leaf, as Professor Gurmeet Singh ji has said that I am from the field of science. Sir, I just would like to tell you that as a lawyer and as a judge, a person is supposed to be jack of all, if not master. Because who knows that at what time, what kind of matter any client is bringing to you as a lawyer, or the case is before you as a judge. I just tell you an example. I was in practice. A man came to me. He said that, sir, my child was admitted in a hospital and my 8 years of child has died. When I was there, because he was in very shabby clothes, not very shabby clothes, not very clean. His appearance was as if he's some laborer kind of, but he wasn't. Perhaps it was his style of leading the life. He said that I was standing beside the bed of my child who had just expired. The doctor occasioned to visit, and he was told that, sir, just this child has died. So he just saw the medicine which was being administered to that child. So the doctor spoke in English, but the bloody hell thing you have just administered is expired medicine. So he heard it. The moment doctor departed from there, the whole staff also departed, took the medicine. He went to the Sri Ram Institute just behind Hindu College. I don't know how come he got the contact over there. He got it chemically examined, got the report and came to me, sir, I want to file case. So I saw the report because I was from the science background. Chemistry, of course, was not such a great subject to me, but certainly I had some knowledge of chemistry because I was a mathematics student. I secured the 10th position at Delhi University. But it was not such a aligned subject to me. So I read the report. I prepared the case, filed the writ petition. And that hospital belonged to the Narottam Puri, the great cricket commentator of the yesteryears. His hospital was somewhere in Rupnagar. So I prepared the case, I filed it. So Justice J.K. Mehra was there. So the case was listed before him. And you just say, because just to prepare a case, because how to prepare the case is, this is really an art. If you are not preparing your case, then certainly it's not necessary that even if it is a good case, you will succeed. No, it's not necessary. How you prepare the case, that's most important. So before filing the case, I just wrote a letter to the pharmaceutical firm, which has happened to be from Germany. So these Europeans, they do their work very meticulously. The moment I leveled charge against them, they sent me the literature of this much thick. Next. So I'm just telling that we have been doing research in this medicine for last 100 years. So these are the developments of these medicines. Certainly not those main documents. I read some of those and just took out the summary and just placed in my writ petition. And when the matter was placed before the court, Justice J.K. Mehra, I was given to understand that he was also science student graduate. Though he used to practice in labor law before he got elevated to Delhi High Court. So I just was able to explain my case because of my science background only. He could understand so easily because his science background. And before any order could have been passed, Narottam Puri and his hospital came to the terms. They negotiated because they did not want that the judgment is passed against it and being reported in the newspapers. And some compromise took place. So what I mean to say is that when you are in field of law, so it's not merely law, because law is not abstract. Law is something which comes from the society, from every walk of life. From every walk of life. Social sciences, political science, chemistry, biology, botany, everything. So whenever, now you have just entered this train of law, now you have to just travel all the places. And that is precisely the reason that wherever there are some integrated courses, they are being taught, perhaps I don't know whether they are being taught from the science or not in the integrated course or not, because I am not knowing much about what the curriculum of the 5-year law course is. But they are being taught political science, that I know, history, and these are subjects. But I think that there should be something about the science also, at least basic science. Now just coming to the second aspect. When I was a student, why this ancient Indian law? I have chosen for you. Because when I was a student, there was a subject, used to be a subject, that was the Indian legal history. So the professors sitting here, they might be just able to recall their student years. So that was one of the subjects. And Indian legal history started from Nand Kumar's case of Bengal, of the Britishers. As if before that, ours was a lawless society. As if there was no law at all. As if we were the barbaric people, we were the tribal areas, we are the tribes. But we know that we were not like that. We might not be knowing that what exactly the ancient Indian law is, you people or most of the people. But at least one thing we know, that ours was a very developed and egalitarian society in yesteryears, and we had tremendous achievements in our ancient India. Of course, there was a time in medieval era that we lost many things we could not preserve because of variety of reasons. Maybe the repeated onslaught on our social structure, education structure, because of the foreign invasions. But even then we could save many things. Secondly, as you would just go into the studies of law in your coming years, when you will there will be a subject jurisprudence. Jurisprudence literally means philosophy of law. And the subject starts from Salmond, Anglo-Saxon laws, Latin laws, Dicey, what the Dicey has said on it, what Handy Man has said about the Indian law, the negative aspects. Except the Raja Nand Kumar's case, there is nothing in Indian legal history which might say that there is something wrong with the English law as it was administered in India in initial years. Then they will talk about that how the Stephen I'm forgetting his first name, gave us the Indian Evidence Act. James Stephen, thank you very much. And how Macaulay and his team made the Indian Penal Code, Criminal Procedure Code. But what were we doing before? Was there a vacuum? If there was a vacuum, then how could we thrive? What the Kautilya was doing, then why we are talking about the succession laws in India when there was no codification like Hindu Marriage Act, Hindu Succession Act, Wards and Guardian Act. When we talk about Mitaksha, the Hindu succession law, then if there was no law, then where from this Mitaksha came? Who were the Yagvalkya? If there was no law, if there is no ancient law, what Akshpad Gautam, when he wrote the Nyaya Sutra, was doing? He was really doing something in the field of law. Then why we are not aware of it? Why that is not being taught to us? Why that is not being discussed? It's not saying, I'm not extolling it that everything there is wonderful. We can be critical to one or two or many sutras, the concepts which are given by those all great people. We have our views, our opinions about the judgments given by the Supreme Court. Yes, everybody is entitled to his opinion, despite the fact that the case has been decided, the law has been given by the Supreme Court. But everybody is entitled to opinion. So is the case with the ancient law also. It may be wrong, it may be right, but we should not worry. What exactly was that? Without knowing, how can we say that if it was wrong or it was right? So, and last but not least, if we are not knowing our past, means we have no future. Because with borrowed things, we cannot go ahead, because those are not from the place where our roots are. So now let's go into what exactly. And one thing I just would like to say to you, because you are the students, as Professor Gurmeet Singh ji has just stated in his introduction, that you are the students who have just initiated into it. I would like you people to just ask as many questions as you can ask, because it will make, because I am, as you know, that since last 20 years I am not in habit of speaking. Being judge, I am habit of writing. And I was director of the academy around 5 years back. So the little proficiency in speaking which I had gained, that has also been lost. So I would request you that as and when you have any query, kindly raise it, because it will ignite me. It will just make me to just explain the things better way. So that's why I'm saying that it's a talk. It has to be both ways. So don't shy away from it. Now, just can anybody? Yes. You can just give it to me. Thank you. What is the fountainhead of ancient Indian law, if we just go into it, before proceeding further, I will just say that there are one thing, very important thing before starting, just I'm taking a little pause, that there are lot many literature in ancient India which generally is stated to be of some spiritual content or religious content by the people from out of India, but that is certainly not. Like Rigved, my professor, Vice Chancellor Sahab, he is from the science background. If we talk about the Nasdiya Sukt, I'm not talking about law right now. So Nasdiya Sukt talks about the Big Bang theory. So it's science in it. It has mathematics in it, Atharved. And it has social sciences in it. It has law in it. So if we just understand this important fact, then only we shall be able to get anything that we are talking about. So now, what is the fountainhead of the law in our society, in our ancient India? That was the Vedas. You will be a little surprised, perplexed, how can it be like that? I'm not going into very broad aspect of it, but just little bit I will just introduce you. And thereafter, Vedas, as you know, that it is called Shrutis because nobody knows that who has written it. But Smritis are the treatises which has been written by some social scientist. I'm not using word says, mind it. If you go word by Rishi, you know that our lingua franca at that time was Sanskrit. And Sanskrit is made up of around, is this language, if you go by the Vyakarana. So that is made of 365 dhatus. The etymological unit of construction of a language. So Rishi, so that stands person who really works upon him to understand a subject. So I am saying the social scientist. So the Smritis were written by the persons who were working in their various fields, may that be the science, may that be law, may that be Ayurveda, whatever that field might have been. So after Vedas, those are the Smritis. Those are treatises written by the social scientists, and the treatises which wrote in the field of law, those are many, like Yagvalkya, I had just stated to you. Rishi Katyayan has also written it. Brihaspati Sutra and Akshpad Gautam's Nyaya Sutra. So these are a few Smritis which are coming to my mind. There are many. And thereafter, many people have, because those were, as you know, the students who are 2 or 3 years of law, they will just identify what I am saying right now, that there is a one section of any Indian Penal Code or Constitution of India, Article 14 or Article 13 or Article 21, right to liberty and right to life, But there are many judges who are expounding in their own words. So was the case with the later social reformers, social scientists, the sages, the rishis. Even after the Smritis, they were expounding it. So the best tika, that is what tika means, the commentary, was written by Kulak Bhatt, and that tika was Manvrat Muktavali. And apart from that, Smriti says that there are many sources of law also. So, one is Vedas first, then Smritis, then 3 more other sources which are not the sources of law which we see today exactly. That is the conduct of the righteous person, the customary law in ancient Indian law, Vedas, then Smritis, then customary law, then 4th is the conduct of the righteous persons, 4th source of law. And lastly, what a person considers to be virtuous in his own understanding. So the students who are in a 3rd year or 4th year or some years in law, they will easily find that these 5 sources of law in ancient India are different from the 3 sources of law which we recognize in present day legal system adopted by India. First is statutes. Nowadays, any law, Constitution of India, Indian Penal Code, Contract Act, Sales of Goods Act, Hindu Marriage Act, Adoption Act. So that is statutory law. Second is the precedents, the law explained by the courts of record. What are the courts of record? Either high courts of the various states or the Supreme Court. Courts of record always means that either high court of any state or the Supreme Court. And lastly, the customs. But if there is any statutory provision, if there is any law, any act, like Contract Act says that what is the legal contract. And custom says that stealing somebody's property and keeping with you, and once you prove the possession, so you are entitled to it. No, you cannot. Because Indian penal law say it is theft, you cannot. You are rather liable to be punished. So when there is a statutory law, then customary law will not be applicable. There is one community in our North India. So they say that if any young boy of their family grows up, so he is just go and steal somebody's buffalo. And if he steals the buffalo and brings back that home, and the person, the real owner of the buffalo comes and says that your son or your boy has stolen my buffalo and give it back. No, we will not give you the buffalo back, take the money, because the first time he has just done this job. So it is a customary law. But in the eyes of law, it is a theft. So customary law, in society, they can do it like that. But if that man approaches the court and reports the matter to the police, a FIR would be lodged, he will be arrested, he will be prosecuted, and if charges are proved, he will be punished. So nothing can override the statutory law. Rest to laws comes after if there is no statute as such, or there is a confusion in the statutes. So then explanation given by the courts of record, Supreme Court or High Court. And if there is no explanation, there is no precedent, that law is called precedent. The explanation, the exposition which has been given by the High Courts and the Supreme Court, those are called precedents. If there is no statutory provision, if there is no precedent, any law laid down by the courts, then customary law is also a law if it is not against the settled principles of law. But in ancient India, because there were not many statutory provisions, the edicts passed by the king were a rarity, perhaps not at all. The only written law was Vedas or the Smritis, nothing else. And that was not the job of the king. He could have made the order, but that order was always tested on the anvil of the law laid down in the Vedas first, then Smritis. If there is something in Vedas, then that is the supreme law. If it is missing in the Vedas, then Smritis. If there is something in Vedas and in Smritis also, and those are conflict with each other, then law laid down in Smritis, that is a bad law. That is a bad law. What is a good law? Law which is propounded, laid down in the Vedas. When there is nothing in Vedas, nothing in Smritis, then customary law. Again, there cannot be any custom against the Vedas and the Smritis. It has to be in consonance with that law or in absence of that. Then, fourthly, the conduct of the righteous persons of society. Who are the righteous persons? Who are acclaimed to be personalities who can be followed. And lastly, when there is nothing, what a right man thinks about. It is correct. That common sense. So, basis, lastly, is the common sense. So, because there was not many written laws, so therefore 5 sources of law were recognized in those days. But by the passage of time, we see that there are some laws in the Smritis also, which are not so good. When we read it, we find that no, it is incorrect. How can we do like that? Yes, there can be something, as I said initially, that we must know that what exactly the law was there in ancient India. We can have our own opinion. If there is something which is against the conscious or present time law, then that's a bad law again. But if there is something good, then that's a good law that should be kept in mind. And if that good law be made the corner, the anchor of our present legal system, the bottom rock of the legal system of present day India, so what's bad in that? So now let's move ahead. So Smritis are regarded as the oldest codification of the rules of Dharma. Now here I would like to just explain word Dharma. I hope that nowadays, may I have a glass of water please? Yes, please, give me. Thank you. Actually, initially, when Britishers left us, so what was the meaning of the Dharma? That was always as if it is a synonymous or English word for the religion. But now this word is being used repeatedly in different connotations, and the right connotation of this word is also very much known to the people. Dharma actually is the word dharma which has originated from dhatu dhri of the Sanskrit language. Dhri means to possess, to be firm, to stand something for. There is a word in Sanskrit that is gun dharma. Gun means the attribute, and dharma means that something on which you are firm. So dharma is the word, you can say that it stands for rules and law for the time being. It has many meanings, but in today's discussion we will use as a word law in English. So the Smritis are regarded as the oldest codifications of the rules of the Dharma. Dharma regulates the rights and duties of every individual in order to ensure peace and happiness by harmonizing the interest of individuals and societies. If we go by the Smritis, if we have enough time to study it, then we will realize that there's almost everything to harmonize the interest of the conflicting interest of the individuals in society. And later Smritikars has tremendously depended upon these Smritis. There is a one Smriti which is very controversial. The moment its name is taken, people start talking about a lot in different manners. But as I said, that there may be something which is against our nowadays conscious, our legal understanding. But that is not only the reason to just throw it away. There may be something, as the gold is embedded in quintals of the ore, mitti ke andar lot many gold ores may be, the gold particles may be there, but if we throw it away, then we are throwing the gold also. So certainly if you read, there are some verses in Manusmriti which are not good law, which are against the conscious, present day conscious, which are against the present day law. So those should be discarded. So we shall just talk about the good things in that Smriti. So that Smriti has got 18 subdivisions and 12 chapters. And we will just introduce ourselves that what those 12 chapters are. There are around 2,649 verses in those 12 chapters. 2,694 verses rather. And 12 chapters. And subject matters of varied complexion, touching every aspect of the human life and society. Chapter 1 is creation of the universe. No, sir, it is not science. It's not science. It's not religion, it's not spirituality. But the cornerstone of our thought process in ancient India was that we are one. We used to identify ourselves with the universe. We are a part or parcel of the universe. That is a theology. If it is spirituality, I don't know. I am not exponent of that. So I said that to understand that what law should we follow, we have to understand that where from we have come. Who are we? What relations we have got with the inanimate objects? If we do not know that who are we, where from we have come, so how can just we give something good to ourselves? So that was precisely the purpose of having this chapter. Secondly, definition of dharma and sources of dharma. So what the law is, whenever I say law, dharma means that is law. So definition, what is the law is, and what are the sources of the law, dharmas. Then celibacy, studentship and marriage. Now in modern legal system, we have no place for celibacy. What the bullshit you are talking about? If anybody says, sir, what a celibacy has to do with the law? Because law in ancient India was for the upliftment of the society. And no upliftment of society in their understanding could take place without the proper initiation, the character building of a person in his childhood. And for that purpose, his attention has to be kept towards just enriching himself. So that was precisely the purpose of that. Then studentship. Then marriage law. Chapter 3 says like that. Then mode of life means of subsistence, householder's code of conduct. When you are married, then what has to be the code of conduct of a married man? And women also. Then rules governing food. I just to tell you one example. I read somewhere, my senior sitting here, they would recall it vividly. I read a story that there was a there were no rains, no harvest for years together in a region. No rains, no harvest, no grains, nothing to eat, and people were starving. They were dying. That was British Raj. So British official went to a remote village, and almost every person was dead. He could find only one or two. So he searched in house and they found that there was an urn full of grains, and that was intact. Then he was surprised. He asked, so many people have died, and you were starving, and you yourself is starving. So why did you not use this grain? Very perplexing answer he got. Sir, no, this is not the grain. These are the seeds for the posterity. These are seeds for the posterity. So these were how come that society, our society, has got or had got, or now it is no more, because now we have the hybrid seeds. The seeds are being produced in Pusa Institute, Pantnagar Agriculture Universities. So now we go and purchase and buy packets, seeds for the vegetables and grains and all. But those were not the times like that. Because if there are no seeds, then what would happen to our posterity? So this is not grain. So those rules came from that chapter. Then rules governing forest hermits. What the duties of a king? Raj Dharma. You might have heard the stories that there is a king and there is a Rajguru also. There was a Rajguru also, like governor and the legal advisor. Maybe like that. But my governor not always used to listen me. He used to just hear me and he used to do as he liked because of the political expediencies. So that's a modern day system. But in those days, if the Rajguru said, no, this is the law, then it was next to impossible for the king to deviate from that advice. And there are stories where the king did not listen. They doomed. They doomed. Like we hear the stories of Raja Nand, which Chanakya removed with help of Chandragupta. Those may be stories, but that has a message in it. So what the Raj Dharma has to be. Then king's duty towards relating to the administration of justice. This is in chapter 7. The subchapter says 8 is king's duty relating to administration of justice. And there are 18 titles of law, because if I just delve upon each and every aspect, I'm just initiating you people only. Then kings and judges. What's the king's law? And who are the judges? There's a word for judges, I'm just not able to recall it exactly. These are Sanskrit words because previously I was a science student, now I'm the law student, and never been the Sanskrit students. The problem, no, Nyayadesh. That's a different word. That is, yeah, you can say Dharmadhikari. Yeah, he's he makes good films nowadays. Sub TV is owned by him. But that is Prabhavidaka. Dharamguru, of course, Rajguru, Dharamguru you can say, but there is a special post for that. I will just, if I am able to recall, then I will tell you. Okay? And in those days, I am pausing here for some time. Today now we see that there is in talukas there are courts of magistrates and civil judges. Then in districts there is a district judge. Then in state there's a high courts, then the Supreme Courts. In those days also, there were also the 4 tiers of the courts. Talukas, Janpads, Mahajanpad, and then on the top of it, king, who used to administer justice with advice of the Rajguru. With advice of the Rajguru. Now, other persons as judges, as I've just told, and then Constitution of Sabha. You always might have seen in the episodes, and those are most of the time there was a serial of Tenali Rama. So you might have seen here. So Raja Krishnadev Rai is sitting, and Tenali Rama is there, and they are galaxy of the persons who are from different field of the society. Few were from the science, few were from the social sciences, few were from the scriptures, few were from the law. And that was the constitution of the Sabha. And the bigger the king, bigger the constitution Sabha, he used to get the advices from varied type of persons. And duty to restore stolen property. That is also there in chapter 8, chapter 9. And creditor means to recover debts. Now it comes the procedural law. The who have just joined this year, they won't understand, but the persons who are in second or third year or fourth years, so as we have the civil procedure code, okay, we have the specific performance act, how to just enforce a contract if some contract is made and other party is not just discharging his part of the duty, then you can file a case in the court of law. So if you have given a loan to someone and is not paying back, then what is the recourse available? So creditors means to recover the debt. So what and case is to be filed, where to be filed, and how is to be filed, and what is to be proved. Then grounds on which the plaintiff may fail in his suit. In the 2694 verses, these all procedures are given. Certainly not in so many words, but certainly those are there. Now we are just hearing our Prime Minister is saying that we have plenty of law, and the unnecessary law should be scrapped. Because just passing the law doesn't serve the purpose if you do not have the robust system of addressing the grievances of the people. If there is a right and no remedy, then there is no law. So, grounds on which the plaintiff may fail in a suit, those are also stated. That he is not able to prove that he had some right, and what witnesses he has to bring, what evidence he has to bring before the judge. And if he fails, then his case also fails. Then comes to the matrimonial law, the duties of husband and wife. Then partition of the property. If the brothers decide that they do not want to live together, what are the duties of son towards parents? Like section 125 CRPC, to maintain the aged parents. Duties of husband and wife. A husband is supposed to maintain his wife. 125. So those similar kind of the verses are there. You might have heard Yatra Naryasna Pujjante Ramante Tatra Devta. And there's 4 or 5 verses. You know where from those? Where is this found? Again in Manusmriti. Yatra Naryasna Pujjante Ramante Tatra Devta. The place where women are worshipped, respected, only there remains the God. God means peace, tranquility, happiness, prosperity, success. Ramante Tatra Devta doesn't mean that Lord Vishnu will come there in his dreams. Okay, gentlemen, you are doing good. Today you worship your wife. No need to worship me. Where from this all law has come? This is a gold in Manusmriti that has to be taken. Shanship, impartible state. If any partition suit is filed, can every property can be partitioned? Certainly not. There is a temple in the house, 3 brothers, everything can be partitioned. But how can the deity impartible state? How temple can be partitioned? No, it can't be partitioned. Mother, no, it cannot be partitioned. So, it talks about these aspects also. Now, I was talking about the criticism, about the Smritis also, which I was initially talking about. There are some criticisms, those are really justified. There are some verses and rules really incorporated in the Smritis, which are really averse against our conscious present-day legal system. But at the same time, there are some rules. Those are really wonderful. As I said, if there are some good rules, so there is no need to just throw them away. We have to pick the good thing and leave the things which are not good. So it constitutes no ground to throw it away. But on the other hand, it would be wise to extract the good ones and reject the rest. For doing so, there has been an inbuilt provision in the Smritis itself. This is very important. I again say, and the law teachers here and the senior students, there is Article 13 in Constitution of India. So Article 13 of Constitution of India says that anything in existing law, when the Constitution of India came into existence, it talks about that time. Anything which is repugnant to the Chapter 3, that is fundamental rights. Suppose in 1935, Britishers passed some law, and that law is against any of the fundamental right in Chapter 3 of the Constitution of India. So Article 13 says that law which is against the Chapter 3 of the Constitution, that is a bad law, that will not stand. Okay? And second part of Article 13 says that was a law about the existing law. Second part of Article 13 says that any law passed by any legislature or the parliament which is repugnant to any of the article of Chapter 3, or that is to say the fundamental rights, so that is again a bad law. That is to say that any law existing or subsequent law passed by the parliament or legislature, if that takes away any of the right which has been enshrined in Chapter 3, that is fundamental right, so that is not a good law. Now you will be surprised that similar provision also exists in this Smriti also. Let's see that. The people who can read the Devanagari script, they can read it. Pratyajedarth kamo yo syatam dharma varjito dharma chapya sukho darkam lok vikusht beyo cha. So what does it say? Reject wealth, money, and also desire which are contrary to the dharma. When they talk about the dharma, means law as expounded in Vedas. So anything, as I said earlier, that in ancient time there was not many written laws, because there was no parliament, there was no legislature, as if they are passing this act or that act. Now one parliament session, whether winter, monsoon or other sessions, the number of laws are passed every year. But those were not the times. The law used to come after centuries. So fundamental law was Vedas, chapter 13, as used to say, the fundamental rights. Chapter 3, if anything repugnant to that. So that's not a good law. So anything which is acquired against that fundamental law, so that is bad. Whether that may be money or wealth, desire, which is contrary to dharma, reject all such rules of dharma, obedience to which leads to unhappiness to some or bring about public resentment. Chapter 6, verse 176. You see, in different times, different type of language used to be used. It's not necessary that the kind of language we are having in our statutes nowadays, that would have been used in those times. So they used to say that any money, any wealth, any house which is acquired against the rule of law, that is bad. And if it is proved, the court may say, king may say, oh no, this is wrong. Either it will be taken by the government or be restored with the person to it belonged. And anything which brings the unhappiness to some or bring about public resentment, that is also bad. So it means that certainly if you are doing something good, so why other person would feel unhappy about it, except the jealous factor. So it has to be like that. It is well known that in law there is the fundamental law, namely the constitution. There are also laws enacted by legislature or rules made by subordinate legislative authorities, which may be struck down by courts of unconstitutional or ultra vires. So whenever anything is done against the fundamental law as propounded in Vedas, then that is ultra vires, the Vedas, the fundamental law, therefore unsustainable. So in Vyas Smriti also, yes, like Katyayan, Akshpad Gautam, Rishi Yagvalkya, Brihaspati Sutra, Vyas Smriti, they have also stated law in his Smriti. So in Vyas Smriti also, similar kind of provision exists. And it says, Shruti Smriti Prananam Virodho Yatra Darshyate. If there is something in Shrutis means Vedas, or in Smritis against the Smritis, or in Puran which is against these two things, Tatra Shrotam Pramanantu Tyordhade Smriti Torah. Means whenever it is found that there is conflict between any provision contained in the Vedas and the provisions of Smriti, Puran, customs, etc., then what is declared in the Vedas alone shall prevail. That is exactly the Article 13 of Constitution of India. For example, Charter of Equality is found incorporated in Rig Veda. I am not able to understand that where from the caste system has come. In our ancient Indian law, there was no caste system at all if we really read it in right perspective. Not from the perspective of the outsiders, the foreigners. When there are provisions of equality, when we just say that in every particle, animate or inanimate, the God resides, it's next to impossible that we can differentiate between a person to person on the basis of birth. That's my understanding. If there is something wrong, as I had earlier said, it seems that those might have been incorporated, though might have been inserted by the persons with vested interest in later years. So for example, Charter of Equality, Samanta, is found incorporated in the Rig Veda, the most ancient of Vedas, and also in the Atharveda. Rig Veda Mandal 5, Sukta 60, Mantra 5 says, Ajyeshthaso Akanishthasate Sambhratro vavrdha sobhagaye. What does it mean? No one is superior. No one is, that is Article 14 of Constitution of India. Everybody is equal before law and everybody has equality, equal protection of law, equality before law and equal protection of law. This is Article 14. Is it not the same? Kindly read it. That's an English translation. No one is superior. All are brothers, bhratra. All should strive for interest of all and should progress collectively. And similarly, Atharvaved says, Samani prapa saha one bhaga, samane yoktre saha wo unismi ara nabhimi bhavat. What does it say? All have equal rights in articles of food. The national resources are for everyone. No have superior right to the national resources than other. May that be Brahmin, may that be any other person. Now let's talk about the stick words. So every member of society, whether he is from the upper strata of the life or the lower strata of the life economically, so they are the spokes of the same wheel. So if 2 or 3 spokes are not working or they are broken, certainly that wheel also would collapse. These Vedic provisions forcefully declare equality among human beings. The Smriti has expressly declared that Vedas constitute the first and authoritative source of dharma, law, source of law. Thus, equality of all human beings is the one of the elements of the basic structure of law in ancient Indian law. However, when we see few patently discriminatory provisions in Smritis in matter of imposition of penalties, the division of Hindu society into innumerable castes, some claiming to be superior or other with varying customs and uses, which has brought about equality, that should be shunned, that should be rejected. So, if there is any discrimination, there was a judge, Justice S.S. Dhawan. He had given a judgment in 1967. Gyaneshwar versus something, that was the citation. In that judgment also he had expounded about the equality, how it is enshrined in ancient Indian books. And similarly, Justice Rama Joyce, who retired as Chief Justice of Punjab and Haryana High Court and belonged to the Karnataka, he was a great exponent about the ancient Indian law, and he was also of view that these basic tenets of equality, that should be incorporated and that should be recognized in Indian legal system also. So if there is any discrimination, then that discrimination always held to be contrary to the law as propounded in Vedas and Smritis. So this is nothing but adharma, nothing else. So in conformity with Charter of Equality in Vedas, in chapter of Raj Dharma, the Smriti has laid down doctrine of equality, the direction to the state to treat all equally, and this is the another verse. Yatha sarvani bhutani dhara dharayet samam, tatha sarvani bhutani vibhrata parthivam pratam. So what does it mean? The king should support all his subjects without any discrimination in the same manner as earth supports all living beings. Chapter 9, verse 311 of the same Smriti. So this verse is equal to the Article 14 of the Constitution of India. So this is one of the judgment. A.S. Narayana Dikshitulu case passed in 1996, Supreme Court 1765, in which Honorable Mr. Justice Ramaswamy as he then was the judge of the Supreme Court, he has just discussed the law of the ancient India regarding equality and decided the case on the basis of that entirely.
A very good afternoon to everyone. Once again, on behalf of the School of Law, I am greeting the gathering. So, needless to say anything, the lecture itself and the interaction itself speaks for how relevant and how valuable it was. And having coordinated this lecture today, I know that as many students from law school who are present here, the same number from other schools is also present here. So all those students who joined us today, sheerly out of their interest in this subject, it indicates the relevance of the topic that we had at hand. So at the outset, I would like to put on record my heartfelt gratitude to our Honorable Vice Chancellor Sir for getting us in touch with Justice Vivek Bharti Sharma ji for this lecture today. And my highest regards for Sir, not only for devoting his time, but for devoting his thoughts and his ideologies and his observation on a very valuable and a tantalizing subject. What we have need not always be the best, but what we should retain should always continue to be valuable. I believe this should be the takeaway from today's overall discussion. And then in such a candid manner, Sir guided the young professionals here for their future prospects also, Sir. So I'm really thankful to you for such a sweet and easy interaction on a very, very in-depth and a far-reaching topic at the same time. I also thank our Director of Studies, Sir Professor Karmi Karsuji, our Director from Distance Education Department and Finance Officer here, and our Dean, Professor Victor Anand Kumar, who is always the sweetest leader leading our team, although not being from law background. All the officers of the university, I see so many of my colleagues who have taken out their time today. So, and needless to say, the students, the research scholars who have come here today to share this academic exchange of ideas. At the same time, the back end support provided by the Office of the PR, Office of the Electronics and Media, and other electrical services along with computer and webmaster services. And please excuse me if I'm forgetting out anything. Hospitality and management, everybody, thank you so much for your support and making this event a success and something which will certainly stay in our minds as an addition to our own understanding. Thank you so much.